Good news, major change and a deviation from long-standing Child Status Protection Act last week, right?
Yes, last week. So around Valentine's Day, USCIS gifted the change in the Child Status Protection Act interpretation for age out calculation purposes on how USCIS will calculate and how they lock the child's age for the purpose of immigrating to the United States along with the parents.
So, what used to happen basically, um, when you file an immigrant petition, so principal beneficiary, if there is a derivative, meaning a child, so as long as the immigrant petition was pending, the child's age was locked. Once it's approved, then the child starts aging out again. But what used to happen generally when you file the adjustment status, adjustment application for your children, right?
Yes.
So USCI used to calculate on the basis of final action dates, not the filing. Now, what's happening?
So now they have shifted to the second table, which is the dates of filing under the visa bulletin. So this is good because most children's child's age was calculated based on the first table, and it took USCI several years to, in fact, reach the petitioner's priority date, which means the child has already aged out because under immigration law, the child age means 21 years or younger. So those who cross that age cannot immigrate to the US along with the parents. But the Child Status Protection Act, introduced in 2002, introduced a special formula on how you can deduct certain days on which the petitioner's petition was pending at the USCIS from the actual age of the child, and for immigration purposes reduce the age to give the child the benefit of immigrating along with the parents. So with this change, it's hopeful that large group are going to benefit. So Ishan, what did they share the numbers? How many people will benefit?
I don't know the numbers, but what I know is that last year, or I think 2020,
Yes.
when the dates moved forward for 4 years, it was on the basis of filing action, not final action. So people have filed their petitions, and then the child aged out. So now, if you have a denial saying your child is not eligible for adjustment based on the aging out criteria, you can now apply, or we say file a motion to reopen and get the child the green card. Many children will be benefited from this new move
That's correct.
and will be eligible for a green card.
That's correct.
And I would say uh, from 2015, because before that there was only one table, right?
Yes.
After 2015, if they don't say that you can go back to 2015, it's our interpretation, and it's not a legal advice. There is no attorney-client privilege here. It's just that, according to me, what I feel is, if they are saying that you can file a motion to reopen, generally it's for 30 days if your application was denied last 30 days. But if someone with a wrongful denial can apply within the last 30 days, I think if your case was denied before, you may still be eligible to file a motion to reopen and get your case adjudicated today. What do you
That's
think?
right, Ishan. So, folks who have, whose children's 485 application was denied for age out purposes, should go back and review the denial notice very carefully and figure out if the specific reason for the denial is aged out due to Child Status Protection Act, lack of the protection from that particular act. Then you probably may have a chance to reopen your 485 through a motion to reopen and argue the child to be given the green card. But in the event, that you're not able to do, then please reach out to us with the denial notice and give us a chance to review it. and we will let you know your options. I mean, your options are twofold here. Obviously, you can file a motion to reopen and have USCIS reopen it. Otherwise, you're always open to knocking the doors of the federal court and file a suit, right? So, take both options. You never know which one is going to benefit you.
I'm getting calls. I'm getting calls that my attorney did not even file my adjustment application because the attorney thought that it's on the basis of final action and which is not current. So what happens there? Can we file?
Yeah, I mean, it's very unfortunate that if the 485 was not filed with the prediction of what's going to happen in the future and the child has aged out, then unfortunately the child is left stranded and with his, he has to find his own means of getting the green card. But now with this change in the policy where USCIS is giving you a chance to reopen your old case, certainly there may be a possibility that your child can benefit out of it. So therefore dust up the file and bring back the notice and approach us and let us have a look at it.
So meaning we feel if we can reopen a filed case which was denied, we can actually file a new case saying that previously, because the policy was not this, that we felt that there's no point filing the adjustment. If we did not file, we may try it and see. I'm not saying that it will be approved or not. If not, then we can simply seek judicial review.
Yes,
Right?
I mean this is a new change, right, Ishan? I mean, guidance has just come out of USCIS that they want to use the second table, but there is still a lot of questions to ask and a lot of answers to be sought from USCIS. Things are not too clear. It's still riding in the water. So, you never know. So, let's go back and look at those decisions if you have. And for those people who still have a chance and have not filed their 485, this is your chance. Review the visa bulletin, the second table, and then if USCIS is authorizing you to use the second table to file the 485 and your child is eligible to do so, then certainly take this opportunity and file the 485.
So to conclude, I would say if you or your child's petition was denied or you did not file the petition thinking that you are not eligible, please reach out to us. I will have my email address and Jagan's email address in the description box below. And thank you.
Yeah, thank you.